scenario. I'm sure his clients like him and leave on staff. Flip sides of that. 2 years in
Everyone could find a seat. We're gonna get going now. So yeah, this is the advanced cyber coverage. So if you're not prepared to hear about advanced issues, please go to the basic cyber coverage, which I hope everyone would be in this panel because this is the biggest room with the most talented people in the insurance industry here. So, all right, everyone, let's get going. So, you know, we prepared an awful lot for this panel, and we put put a plan together, put a nice template together for everyone, and my good friend and colleague Meredith said she wanted to do something fun instead. So what we decided to do is that she's the only broker up here, and we have a bunch of underwriters. We're going to have a debate style, and it's going to be brokers versus underwriters. So it's going to be all the underwriters versus Meredith. So you prepared for that?
Good luck to me.
Okay.
I don't think we will win. I think we're in
Meredith has a list of 25 coverage specs, and we're going to debate all those coverage specs against her right now. So, which I think would actually be a cool format, but that's not what we're going to do today. So, we have a bunch of topics that we put together. We're going to talk about cyber war and terrorism. We're going to talk about BIPD, intangible assets, critical infrastructure, and PCI. These are all topics that we think are really worth getting into. We're going to focus on coverage aspects, focus on the underwriting side, and I think we're all set. So I think everyone knows everyone up here, and we're just going to kick it off with Ken Goldstein from Chubb, who's going to talk about cyber war and terrorism. So obviously hot topic, but it's also a topic that I think gets mentioned an awful lot. No one quite knows what it is. So we're going to focus on what is cyber terrorism, maybe get into a couple of examples of cyber terrorism, and then we're going to get into some of the coverage aspects of it. There's war exclusions. Do they apply? Do they not apply? How should a client be addressing the coverage? We're going to look at some of the underwriting considerations that underwriters should be talking about. So Ken, you want to kick us off?
Sure. Thanks, John. Good morning, everybody. We appreciate the opportunity to be here with you today. Can you hear me okay in the back? Great. So definitionally, cyber terrorism, I guess in layman's terms, some type of attack is going on. As an example, a nation-state attack, and it's typically designed for a few different types of purposes, maybe intellectual property mining to get a competitive advantage from the folks that are actually attacking in the first instance. Maybe they're trying to use private information and they're going to sell it off, so there's a financial gain type of play to ultimately make. Or perhaps maybe the attack is ultimately for religious or political type of purposes. You might have seen website type of defacement going on in connection with things as well. Different ramifications, starting with really theft of trade secrets or business partner information, PII. Could be virus transmissions. The last panel talked about Heartbleed, from really an organization over to its customers, business interruption, extra expense. And although not necessarily advanced per se, I think in terms of the coverage response, and we'll get to the topic of war that John mentioned before, you're talking about forensic expenses. You're talking about compliance assessment to figure out whether you have notification obligations. Perhaps if it's going to be made public, call center, basically providing folks with monitoring and restoration. And then if you flip it around liability-wise, you're talking about unauthorized access type of claims. Maybe you're talking about regulatory to the extent, again, that it's been made public.
So, I mean, is it a war? I mean, I think most carriers have war exclusions in their forms. Is this something, that brokers and your insureds, Meredith, are looking at and saying, wow, I have this war exclusion here. What if I get hacked by a nation state? Is my claim going to be covered if there's a data breach?
Yeah, well, we're not as concerned about the war exclusion as we are the acts of foreign enemies, right? So war is war. I don't perceive war to be terrorism, right? So I'm not really as concerned if you have a civil war or war exclusion on your policy. The acts of foreign enemies is kind of gray, right? So we prefer to have, a affirmative carve-out for coverage for cyber terrorism so that acts of foreign enemies statement or wording doesn't come into play when we need it.
And I think, honestly, it depends upon the nature of the attack. You have a scenario where attack is designed to instill bodily injury or property damage. I think it's clear in that instance. It's tantamount to the use of force. You could have a war problem, and your typical language in your policy based upon directly or indirectly arising out of or resulting from war. You could have what Meredith just touched upon, which is really state-sponsored type of attacks going on, typically for intellectual property mining, and I think that the issue is an outstanding one. We haven't seen that litigated from a coverage perspective, and honestly, I could anticipate that ultimately occurring. And if you remove yourself, though, to Meredith's point, from state-sponsored type of attack, you're probably not within the context of war and not that concerned about it from the standpoint of the exclusion being in the policy.
And just to add to that, the element of war was at a Department of Defense panel on cybersecurity, and there's a lot of confusion even in the Department of Defense on what's considered cyber war and who's responsible for it. It actually got fairly heated. An Air Force general who's actually in charge of cybersecurity got into not a yelling match, but a serious argument on within the context of who's responsible. Is it the military, or is it the companies that are being hacked as a result of what we'll call cyber war or cyber terrorism? And really, I think from the insurance industry standpoint, we think we have a good idea, or at least the assumption is that the government and the military is all over this. For what I saw from that is the government, the military, Department of Defense, Department of Homeland Security knows less than we do on this topic, which is a concern from a carrier standpoint.
Yeah, I can add to that. I mean, just I think we do over-rely on how much the U.S. government and other governments are involved in these types of activities. But I think, going back to just the practical of what we can control in our piece of it, we have insurance contracts and we design those policies and those definitions in a certain way. And at the end of the day, it's our claims adjusters that are going to have to be able to interpret that language and manage that. And I think, so we're working pretty aggressively with our claims groups to contemplate what that would mean. One of the things that we've discovered in just talking to some of our vendors that are experts in this field is how can you even determine or prove that it was, in fact, a state-sponsored attack or a government or a hacktivist? In a lot of cases, they're not going to want to take credit in the event. So it could take a year before you're even able to find out who was actually the perpetrator, the cause behind the event. So you translate that over into a claims handling position where we need to take a position with our client. It's a very complicated issue, and I think the point is that it hasn't been tested yet, and I think it is something that we're going to continue to talk about for some time.
Yeah, just on the topic of advanced cyber, it's more advancing cyber. We like to think the basic is kind of what everyone talks about, privacy breaches. But really, I think where cyber grows is within kind of the touchy or the difficult, the war aspect, but also terrorism. And we're only going to see that advance with claim events and circumstances and how we react and how we respond to those instances.
And just to note, the cyber policies that are out there today cover financial loss, right? When I think cyber terrorism, I don't think financial. And maybe this is for you, David, down there. I think bodily injury, property damage. I think infrastructure. I think utility. I think all of those things. And so we're not there yet. And I don't necessarily know that our policies would actually respond to what we think they would respond to anyway. Would like to get your view on that.
Yeah, sure. so Meredith makes a good segue really into our next topic there. And
I just wanted to get David to comment.
Yeah, and that's where we're going with this.
Oh, okay.
Do you want to moderate?
No.
Told you we'd lose.
I'll go sit down.
Stacking the deck.
Clearly, we all report to Meredith now.
Just because she did the video, she thinks she's...
Right. Well, Meredith created that great video earlier. Let's give a round of applause to Meredith for her videography skills. So, Axio is we're a small firm doing risk engineering. We're working with lots of companies that are very concerned about property damage and bodily injury risk as a result of cyber. I'm just curious how many of you are concerned about it or work for companies that are concerned about property damage and bodily injury from cyber. Okay. So it is a small segment. It's typically the industries like energy, the chemical industry, other process manufacturing industry, utilities that have this exposure. And it was first proven, just a little bit of history, in 2007, the Department of Homeland Security and the Department of Energy destroyed a 27-ton electric power generator in a parking lot out in Idaho by hacking into its control system. And so this was the first strong evidence that property damage and potentially bodily injury can stem from cyber events. And then we all know what happened in 2009, 2010 with Stuxnet, which destroyed 1,000 centrifuges at an Iranian uranium enrichment facility. And so that was the first use in the wild, if you will, of a cyber weapon that caused pretty substantial property damage. So for firms whose operations depend on industrial control systems, this is a new vector of risk, and policies generally are either silent or are designed explicitly not to respond to that kind of risk, though that's starting to change.
Yeah, so I think we've gone to these conferences for a really long time, and we've talked about data breach response. I mean, I think that's a topic that everyone is really comfortable with, and even privacy law and unauthorized collection. But I think this is sort of the emerging new exposures when we talk about cyber risk is, the BIPD element. And, Dave, if you can maybe comment on what's going on in the traditional insurance market. I mean, are they equipped, do you think, to handle the exposures? Are they putting exclusions on these coverages?
Well, a lot of underwriters we've talked to will say, well, we're not really considering losses of that type when we underwrite a property program, for example. And so a lot of property programs are riddled with exclusions. Policies are typically either silent or they have what I call a partial exclusion. So there's a really popular exclusion that I call the jewelry box exclusion because it excludes primary damages resulting from cyber, but includes secondary damages that result from cyber events from a property perspective. And so those secondary damages have to be along defined perils. And so it's sort of like buying a jewelry policy that covers the box but not the ring, right? And so I think there's a lot of concern. There's a lot of concern in the companies that we're talking to about how those exclusions will be interpreted for a cyber event, because many of these events, it's very difficult to prove attribution. The forensics are hard. And so where that line gets drawn between what's primary and what's secondary damage under that exclusion is problematic. Silence in a policy is also problematic because underwriters will say they're not really thinking about this risk when they underwrite a property program or a casualty program. And so I think if your policies are silent, you have a very high litigation risk. And then there's a third category of exclusions, which are very strong exclusions coming out of the London market. There's an exclusion called CL380, which essentially negates the policy in the event of a cyber event. I mean, it is a rock-solid exclusion. So that's what we're seeing. I have talked to a couple of firms who've told me they've gotten letters from insurers who have policies that are silent. They have policies that are silent, and their carriers have provided them letters saying, yes, you can interpret silence as coverage. And I've spoken to one company that claims to have a full limit affirmative cyber inclusion, but only one company. I'm still looking for number two.
I think that the classic example of being silent, most companies carry commercial general liability insurance, and if you don't have an exclusion in place, if you have negligence or an occurrence, failure to adhere to your network security or privacy policy, if it results in a named peril, BI or PD, you're not excluded. Maybe absent the intentional acts type of issue.
Okay. So, I mean, where do you guys anticipate the trend on this going? Is the cyber BI PD, is that type of loss something that's going to be in the standalone cyber market in the next 5 years, or is it something that the traditional P&C market they'll get their arms around it and they'll affirmatively provide coverage?
Sure. Well, go ahead.
I think from an underwriting standpoint, the underwriting thought process is here. So it's in this room where the expertise is as it relates to cyber. But I think on the property side, really interacting between those underwriters and these underwriters is where it's going to come. Or if it transitions even further into a cyber policy, then I think the GWP within cyber world changes drastically.
Yeah, I think I agree. I think the expertise needs to be there. So the property group, to Ken's point, if they're not contemplating it, they may be covering it. And I think companies are not going to stick to that over time. 5 years from now, the way technology is embedded in all sorts of devices in our homes is going to transition that need and that awareness to a much higher level. So I think it's just inevitable that this is going to become an everyday issue for everyone in all lines of business. Now, the expertise, as Matt points out, that's going to be the key. You need to be able to underwrite, you need to be able to price for these things. So I think it depends, I guess, a little bit on where this is going to happen. It could create another sort of area or expansion of standalone cyber. But I think the challenge that we're going to run into, quite frankly, is capacity. How much capacity can we offer out of a standalone cyber market in relation to what the property market can and what the excess casualty markets can? So I think we have a real challenge on our hands. So I think it's sort of TBD for now.
Question over there.
I also think the response of we didn't contemplate that is kind of an afterthought at this point from a property standpoint. Clearly, they didn't contemplate that. Now they very well should because it's what's happening right now.
We have a question from the audience.
So in May, ISO rolled out the CG 2106, which is an exclusion that is supposed to be auto-attaching to CGL forms to exclude BI, PD, PIAI arising out of the data breach. How do you see this endorsement, if carriers adopt that, affecting the coverage going forward?
I think good question. I think in the first instance, it depends upon the company's desire to adopt that type of standard, or whether they choose to either remain silent to the prior points or perhaps build in affirmative coverage. To the extent that you decide to fully exclude in an absolute fashion issues associated with cyber, then your risk transfer opportunity isn't there. You're going to need to look elsewhere. So maybe it ends up in the standalone market. Maybe it ends up in a different area.
So there is a big development in the standalone market. I don't know. Right before RIMS this year, AIG announced a new product called CyberEdge PC, which provides difference in conditions coverage for cyber. So it'll reach down and provide service primary for those traditional lines of coverage that have excluded cyber and otherwise serve as excess capacity. It also covers, expenses associated with response and so forth. So that's, in my opinion, that's a huge development in the standalone coverage realm for property damage and bodily injury coverage. And John, I think it remains to be seen, because you could imagine that maybe we have standalone coverage, but I've talked to a lot of risk managers that are uncomfortable with the idea of a separate program that also covers property risk or liability risk. And so I think it's too early to tell, but we have seen that big market moving development over the last couple of months.
Yeah, I just want to jump in specific to the ISO. So there's the 06, the 07, and the 08. So they're all variations. So one all-out excludes both network security and data privacy. One excludes data privacy, but it also provides a carve-back for contingent bodily injury, bodily injury under coverage A. So there's different variations. So I think the struggle that I think some of the carriers out there have is that silence in some cases may be better than taking a position. Because if you start to provide carve-backs, then you have to start to underwrite to the carve-back you're providing and pricing for it. And so right now, from what I understand, many of the casualty markets have not embraced the ISO in exclusion. However, my understanding, I was not at the ISO conference, but there was a separate ISO conference to discuss this, is that the industry in general does not desire the intent to cover cyber under the CGL policy. That is really why ISO came out with the exclusion. It is a clarity of their intent. It provides the tool for those CGL carriers to exclude it. It's been filed in a number of states, and some carriers have actually filed rates for that. So I think we're in transition, I think is sort of right now. I think it's sort of the first chess move. People want to put that chess piece out and sort of see what is everyone else going to do, what position are you going to take. But in general, from what I understand, not able to speak on behalf of the entire insurance industry, is that CGL right now, the intent was never to cover that because it's not being underwritten for and it's not being priced for.
And I think from a standalone marketplace, it's forced awareness from a broker perspective. Brokers can no longer kind of take the approach of depending on which broker, obviously none here. But, where does the CGL not cover this? Well, the ISO changes clearly show this is the intention. And, the standalone marketplace, I think from a submission flow standpoint, you can feel that and kind of feel the momentum within those changes. And probably more so on the small business, medium-sized business space. Kind of given that typical ISO buyer, assuming that the GL extends.
So it definitely sounds like there's a bit of a gray area that still needs to evolve and play out. Toby, how does the NIST framework play in, and what is the government trying to do to help insurers along with protecting critical infrastructure?
Yes, everyone there's been a lot of buzz about the cybersecurity framework, and I think it is a great development because the framework is a lot of people confuse it as being a standard, and I was able to participate in the fourth workshop to develop it, and it was very clear that there was no intent for this thing to be a standard. In fact, it was a fear, it was a concern. But we've already seen some standards organizations adopt it because NIST developed it. But at the end of the day, the framework is a really nice development for companies that are just looking for a way to identify and measure what sort of cyber exposure they have. Whether you're a company that has very limited capability controls or you're a very large company. But at the end of the day, the one thing I think that a lot of people miss on the framework is that it was designed for critical infrastructure. It was not designed for all businesses. Now, it's being used and it can be embraced by other industries, but it's primarily designed for the financial services sector, the energy sector, utility sector, et cetera. So that is sort of the core focus of it. So I think it's a really nice tool that is being embraced by a lot of the ISACs, and they're bringing it in and they may be adopting it into their standards. But as far as organizations that are looking for some sort of a framework to start to identify and assess what their cyber risk is, I think it's probably one of the best tools that's been developed out there. It may be a little bit too robust for some of the smaller organizations. I think that may be one of the weaknesses, but other than that, I think it's a really great development.
Yeah, Toby, what's an ISAC?
An ISAC? Information sharing something.
Analysis.
Yeah, analysis, right. So they set up ISACs right now. In fact, to me, that's one of the real big developments was Department of Justice and FTC coming out and talking about antitrust sort of being more lenient towards industries that are going to share information about cybersecurity. That was part of the executive order in addition to the framework. So when they passed that or provided that notice, immediately the retail sector, granted it was right after the Target breach, announced they were going to have an ISAC. But the ISACs are a tremendous resource for industry sectors to go in and tap into what's going on to other companies in their sector. Retail sector has a very different exposure base than what the energy sector has. They're seeing different types of claims or activities and hacking and trends. And they have different control mechanisms. Some have operational technology concerns, some have information technology concerns. So I think that part of it was a real nice development for us, to help manage the risk.
Does anyone anticipate the government doing anything else to impose any type of standards or, even on the theme of some overlying federal legislation? Just wondering what you guys are seeing in those areas.
I know there's talks of a cyber attack treaty, so really a group of countries, Russia, China, United States, really putting together a cyber treaty in which primarily based on IP and theft of IP, so that's really what's driving that need. But at the same time, I don't know where that would go or how the process would work, knowing our relationships with China and Russia right now. But really, the driver of that isn't so much, the data breach and notification, where I think a lot of our federal kind of focus is, but the international focus of IP and theft of IP, which kind of brings us to theft of IP. John, I don't know if you want to.
No, please go ahead.
Okay. So one of the questions is, does cyber standalone policies address or cover, IP theft? And not to say and speak for the industry, but I would say the answer is not adequately. I think a lot of the fear from a underwriter's perspective is really the economic value of IP And that's something that's the hardest part of this whole process of really putting this on a cyber policy. And this is the only stat we'll throw out, hopefully, during this whole session. Obama estimated that the annual cost, President Obama, I should probably clarify that, estimated cost.
Because you're all very confused.
Yeah. Cybercrime and espionage on an annual basis is $1 trillion. So McAfee just came out last week using some different statistics and estimates that the annual cost is $445 billion. So from an insurance standpoint, the estimated, I would say, high-end, a $2 billion GWP industry from a cyber standalone with $445 billion in losses, I don't think we would be sitting here in the Hyatt Bellevue right now. So most of us probably would be unemployed. So that's really a focus of really when you're working on policies, and a lot of markets, both domestic and international, are capable of insuring this. So the agreed, and typically what it is an agreed upon value, which is hard. And I think from a insured and broker perspective, it is a very touchy subject in that likely when that theft of IP happens, your interest from a insured standpoint, and we've seen this with a few claims, AMSC, which is a wind power turbine company who's suing a Chinese company named Sinovel for over $1 billion. Let's say we're working through what are the agreed upon values of this IP, which conflicts and contradicts everything that's in their publicly stated SEC statements, that the value and ensuring that value creates a lot of issues, especially when it's a value going into a breach or a cyber theft event. I have serious concerns both from a D&O standpoint, so either ensuring that, but really a derivative action alleging those damages when it is theft of IP, which we saw in the AMSC case too. So the derivative action was based on the insured's or client's inability to track and control their vendors, where in this case the vendor and actually a contractual relationship contradicted what the actual value of IP was. So I think, from a trade secret standpoint, from a theft of IP standpoint, these policies, and I'm speaking very generally, I know that there are policies that do this, but for the most part, the hesitancy is on the economic value of the IP versus the forensics and really the research that goes into determining what happened, which also is a little bit different from the third-party IP theft. So, the coverage for liability associated with theft of IP of others, that should be built into most, if not all, base policies at this point. And anything?
Yeah, no. So I think the trend that we're talking about some coverage areas in IP and BIPD, trade secret, sort of evolution in the cyber market, and I think we're all we're in that phase where it's data breach response and it's privacy and network security. It's been established now in over the past 10 years. Are we as cyber insurers and brokers, are we ready to kind of jump into another area and just say, okay, here's some, cyber's changing and there's new coverages and we got to get our arms around that because that's the demand and that's what our clients and, that's what they're asking us to do. Or should we say, hey, listen, guys, we got to get this market right. We got to get this correct and we got to establish rates. We got to establish pricing models and, we got to get the legislative landscape and precedent and get all that settled first. Just curious to hear what everyone's thought on that. I mean, should we have another insuring agreement? Should we have 15 insuring agreements in one form? Like, where do we stop? Where we get to a point where we need to manage this a little bit and make it a little more like insurance and not just the Wild West that we've all been running in for the last 15 years.
I think that the innovation piece doesn't stop. I mean, cyber is evolving. You have to be attuned with what your customers need, and if that brings into the discussion topics of BIPD or valuation of IP, then you need to be able to analyze that. But Matt made a good point, at least with regard to IP specifically. How do you evaluate it? Can you evaluate it in an objective type of way to get comfortable enough with it. I mean, related to that is you still have business interruption and extra expense coverage under your cyber form. That might not get directly to the theft of IP, but if you have an attack and you have a business interruption, some of that stuff is probably tied into that overall business income valuation at the end of the day.
I mean, I just, from the broker standpoint, I can tell you that most of our clients are not even concerned with the business. I mean, some are concerned with business interruption if they're directly affected. I can tell you that more often than not, the question is to us is my reputation, a harm to my reputation, or if there's theft of IP and that goes. I mean, you can value it, but that, I think, is along the line of reputational damage because that's your company, that's what you own, that's your whole being. So we get tons of questions all the time. Meredith, this is great. I'm happy that we're insuring this risk. How can I insure my reputational harm? You know, if I have a breach, we can talk about Target all day long. You can look at the stats. You can look at their declining sales. You can look at everything, that's followed on that. The insurance products don't talk to that today.
I also think you have to look at the underwriting expense associated with valuing IP and the buyers, the amount of buyers that there are. For let's use a small size, medium size, middle market business. I mean, the amount of time it would take the underwriting team, especially the cyber underwriting team, to truly underwrite and understand the economic value of the IP. You may even be losing money at that point, just knowing where the marketplace is. But I also think on the higher end, that could change. So if theft of IP is something that we are very comfortable with, and I know there's a session tomorrow on valuation and valuing IP. I think Mandiant is speaking. I mean, that's a component that I think will change. And the underwriting expense associated on big business, obviously the losses are bigger losses. But the buyer, I think, might be more interested in at least discussing that, talking through that process. And actually that underwriting process probably adds some value to each carrier through that relationship. But again, I think there's negatives to valuing your IP on a regular basis because if and when it is stolen, you have a defined value, and your shareholders more than likely are aware of that defined value.
I just to kind of add to that a little bit, I think, you have to look at cyber as a peril. And oftentimes we've been looking at cyber as a product. And so in insurance, if you're a history major, which I'm not, but, we're kind of at a really exciting time right now where insurance is literally evolving right in front of us in this area. And the technology is changing the way we're looking at traditional lines of insurance, not just the way we're looking at the standalone line of business. So I think it's a really exciting time, but I think Matt's point is a good one in that, we as insurers and as brokers, our job is to provide solutions to our clients where they identify exposure and risk. And we need to be able to assess that risk, quantify it, price for it, and be able to make money while insuring it. And if there's a market for that, I think we're always going to continue to look and try and understand where those areas of exposure are and risk are so that we can help our insureds with risk transfer or help to mitigate that risk. I think intellectual property falls under that umbrella, but I think there's enough going on right now that the capacity that's probably required to insure that for the companies that will want to insure it isn't available for some time, and there's a lot of other areas that we can catch up on before we hit intellectual property.
It's along the same comment you made earlier, Toby, about not enough capacity to insure first-party loss on a critical infrastructure or utility. Why is it that we're focused here mainly domestically, but internationally, and we talk to our colleagues overseas that sell cyber insurance. Why is the demand internationally all first-party driven? I understand on the liability side they might not have the demand for the legislation is not in place and the laws aren't there, but why are they so concerned about first party overseas?
I think it's a couple of things, but just on the capacity, I think just one more point on that, which I thought was just a real interesting comment. A representative of the Department of Trust and Clearing was part of the cybersecurity framework, and Peter Foster was on the panel, and he referenced that one of the largest cyber towers standalone cyber towers that was available in the market was $350 million. So that was on our panel. Then this representative from the Department of Trust and Clearing came on later on. He said, I don't need $350 million of insurance. I need 36 trillion, right? Now, I mean, obviously he was joking a little bit, but I think there's a certain element to that capacity play of where we can play, where we can insure in the middle market, or where we can handle the big guys. On the international side, I think, I kind of feel like whenever I go over there, I'm in a kind of like a cyber time warp. It's not a matter of that there isn't going to be a value proposition in the liability and the breach response over there. It's just that there aren't notification requirements or as many or anywhere near the same level of awareness that there is here in the United States. If you look at Mark's slides earlier, he talked about sort of the liability trend cost going up. And the breach response, well, it went up. We can argue those numbers later. But I think, generally speaking, we're managing that breach response number down because we have better controls and we have better vendors to handle that process. Overseas, they're not seeing that trend, right? They're not seeing the requirement to notice going back to Choice Point in California in 2003. Think about where we all were at that point. We were selling majority first-party cyber coverage, business interruption to specific clients that wanted tangible coverage for their loss. And on top of that, we were selling it to technology firms and financial service companies that were already in a litigious environment for what they did. Now, going internationally, I think that's the lag. I think that's what's driving behind it. When you're sitting in front of a client, the comment was made earlier that, they see value in the business interruption component of the coverage. They understand it, and they don't have to worry about, well, I don't think I'll be sued, that type of thing. So I think that's the biggest difference internationally versus domestically, but I think what's really driving that is it's just different regulations, and it's a different legal environment.
But isn't there not enough capacity internationally for that first-party business interruption?
Well, I think where they're being able to play is sort of where we're still playing on the first party. So if you're talking about critical infrastructure, then yes. But there's a very large market out there for business interruption for the clients that we insure every day.
Yeah, I think domestically, we as in the broker community and the underwriting community underestimate, and I think Tom Kang mentioned it, but they underestimate the exposure when it comes to these coverages and not so much the breach response coverages. And I did say one stat. There is another one, but 80% of most companies' value and sources of revenue derive from IP. And I think a lot of the broker community and underwriting community think when they hear IP, they think patents, copyrights, trademarks, and that's it. When in actuality, it's the entire company, not entire, but obviously 80% of the company. It really is considered IP in the context of stolen IP. So that's something that, if a company really sits down and looks at not just their balance sheet, they have the intangibles listed out, but if they look at what would happen if this was stolen, that they know a value there, and if that is something that's insurable, or at least they understand that that's the risk, that's probably driving where the coverage would go, which is why I think internationally it's the business interruption, because the awareness that there is no need for, not necessarily no need, but there is a less of a need for breach response, but there's also that interaction buying a cyber policy for the business interruption side.
So we're going to shift gears a little bit, and we're going to talk about sort of the topic du jour is PCI. I think, we're going to spend, I think, a whole entire panel later on today or tomorrow, I'm not sure, but on PCI. But we did want to talk about it, touch upon it today, since we do have the experts up here. And we're going to kick it off with Meredith. So Meredith, explain to the audience, when we say PCI, we have PCI sublimits. What is the coverage? What's being provided? What's a fine? What's an assessment? What are fraud costs covered? Just maybe you could just give a little overview on PCI, DSS, and then we could kind of kick off a bit of a topic discussion on that.
Sure. Well, we're currently in evolution right now, and I'm sure that everybody on the panel from the underwriting side would agree. About what has traditionally been covered, what's covered today, and what needs to be covered down the road. So let's break it out into two buckets. You have let's call it operational bucket, which is the fines and penalties. You're an organization, you're required to be PCI compliant, and you have, as an operation, as part of your operational due diligence, that's what you need. And there are obviously fines and penalties that can be assessed against the organization for failing to be in compliance with that by the card brands. To my knowledge, they range anywhere from $2,000 up to $500,000 in those fines and assessments. And traditionally, our policies, and I say traditionally, we really weren't covering any PCI up until a couple of years ago, but traditionally meaning up until today, the policies have only covered PCI fines and penalties. I think what everybody can attest to, anybody that's been through a retail breach, either themselves, meaning as an insured, broker handling a retail breach, or underwriter, obviously, dealing with a breach, is that's not the way these things are playing out. All right, so what we're trying to do here is move that coverage from just that fine and penalty that traditionally was covered to, let's go now over to the other bucket, which is called assessments. Right? So assessments could be anything from credit card reissuance costs to fraudulent charges, to any type of case management fees, and et cetera, which I know you can talk about ad nauseum. Those are the types of real meat and potatoes and money damages that our clients are really, above and beyond that fine that they are incurring. So what we're trying to do in the marketplace is obviously move the language that way to make sure that the policy not only applies to fines and penalties, which tend to be on the lower end, or maybe not on the lower end, but does not cover the bulk of what's really going on there, to covering all of the fines, penalties, and assessments. The problem is in the insurance industry is any policy you pick up or any endorsement you pick up that's PCI related is what the underwriter's intent is for that coverage. And this is what we struggle with, are all of those costs covered under that one sublimit? And so say you have all that coverage in there. So if I'm going to my retailer, for example, and saying, okay, you have a $1 million sublimit for PCI, does that include the fine, the penalty, the assessment, the credit card reissuance fees, the possible fraudulent charges that you'll be on the hook for? Or is that just the fine and penalty, and maybe the definition of damages would pick up outside of some of those costs? There are some insurers that have definitely made changes to their policy forms that make that very clear and very specific. There are other carriers that are not specific in that, and not specific enough for us to feel comfortable and to tell our clients, well, you only have this $1 million bucket and that's all you have, or you could potentially have more than that $1 billion bucket. So we're struggling with the insurers' viewpoints on where they're putting those cost coverages. Are they putting it under PCI? Are they putting it under damages? And quite frankly, what is exactly covered in those, within that scope of coverage?
John, do you want that one?
What is PCI? Are we okay? Would we have to not say that? It's the advanced panel, right? You called me out on ISAC. I got to call you out on PCI. Right? No, I think one of the key components I would just add to that is that what the contracts generally have is when you're enforcing the fines and penalties of the assessments, it's being done so under a contractual requirement. So that's a key component of how your policy is responding. Generally speaking, the way damages will come into play is it's when it's third-party damages that is coming from some sort of level of a negligence. Well, when PCI or payment card industry comes in or the financial institution, whoever it is, that's coming through to the retailer for payment, they're just saying, look, you're required by contract. It's not something that they're saying this is because of negligence. They're not having to demonstrate negligence. That's where you get into this issue of definition of damages or breach of contract damages in the insurance contract. So you need to be very specific in making sure that you understand that this is a contractual liability and the policy needs to respond accordingly.
And
So
maybe
I'm still a little, unclear. So fines and penalties sounds like it goes within a sublimit. The damages sound like a contractual liability, and unless you're carving back that contractual liability exclusion, an insurer can cite that and say, contractual liability, we're not covering any of the fraud costs or anything beyond fines and penalties. Should that be something that you should be asking for and saying, hey, should this contractual liability exclusion, this needs to be carved back, and is it your intent, underwriter, to cover the credit card fraud costs?
I can tell you today, when we're talking to our clients about what they have PCI related, I only promise them what's in that sublimit, period, regardless of the other way that you can analyze a contract. And obviously we're going to look at other areas of the policy, but I don't feel comfortable, and our team doesn't feel comfortable today telling a client that they have more than what they have in that sublimit, even if the language is unclear. So to answer your question, yes, we do need more clarity. We need to push the envelope on that. We need to be seeing where we can get more for those costs. That's not going away. What we've learned with these breaches is you have the card brands, you have the the merchant banks, and then you have the merchants, and everything comes trickling down, and that merchant's at the lower end, and that's it. It's on them, and everything's been, the processor will have like this reserve fund, right? And they just siphon money out of that, and everything comes down to the bottom line. So how can we get broader, more coverage in the marketplace for those without any discrepancy or ambiguity?
So you make a point on the negligence versus the contractual triggers. Aren't these policies written broadly enough that you're going to trigger an insuring agreement, whether it's a privacy and security wrongful act, a security breach, a data breach? We're all using different terms, but isn't there enough to get past the insuring agreement and get into your policy, and then you're looking at how that thing's going to be adjudicated?
How does your policy respond?
We haven't had any claims yet, so.
I think
I think the key component of that is where Meredith are trying to get at is the forms need to be more clear. It's more important to say specifically what your intent is, so that especially if you're building a tower, of what the primaries terms are and the sublimits and the total limits and what falls into what bucket, and then what transfers up the tower. So I think the clarity of where it falls is more important. No one likes to hear, well, we think it's covered there, right? We want absolute clarity for our policyholders, because when we handle that claim, we don't want any surprises. So I think that's the key component, of what we're trying to address is we're not saying one way is right or one way is wrong. We want clarity on how it is meant to be, so that if it comes in, there are no surprises.
And one of the way to get clarity around the issue is have an affirmative insuring clause and carve back liquidated damages and carve back breach of contract, so that the policy ultimately works together effectively.
And there are one or two that do that, but that's not the majority, right?
And even within the contract, the PCI contract, are the merchants, are they taking on any contractual assumptions and saying, you could recoup some of these fraud costs via this PCI contract, or there are certain liquidated damages, for lack of a better term? How are these these PCI contracts structured? Is there anything that the banks can go and say, hey, we have this agreement and we're going to recoup these monies via the contract? I don't know if anyone has actually even see that kind of play out in a claim situation.
I mean, 2 of the 5 card brands contracts are even more punitive than PCI itself. So that should tell you something on where. I don't know who's. This should tell you something on where PCI should be going, if not eliminating itself, because I think the card brands see, the contracts are what applies, and then the PCI DSS situation. And I think when we refer to it as fines and penalties, everyone thinks regulatory fines and penalties. Not everyone, but a lot of the broker community, underwriting community thinks fines and penalties are these insurable. Well, in the context of PCI fines and penalties, it's unregulatory fines and penalties. So I think that's a part of these contracts that's important to delineate, in that if the contracts for 2 of the 5 card brands are beyond what PCI DSS requires, how long is PCI DSS?
I think that's a key component of clarity, is that PCI is the standard that the card brands developed in concert with a lot of the large banks, right? So the standard is what's used to gauge whether or not the brands are going to enforce assessments under contract. So the contracts are going to happen one way or not, right? PCI standards are referenced within the contract, as you say. The big credit card companies, they're going to enforce that contractually. So we've seen it happen. We've seen that's how it happens. And so that is a real point of clarity that needs to be understood in the insurance contract, because if they're just going to enforce contractual liability, you need to make sure that the policy is going to address it the right way.
Good.
And one of the questions, John, you asked me, you said, well, Meredith, where's the litigation, right? And and I have this note here saying it's really, there really hasn't been a lot of litigation, and it really is dealt with in the back room and everything contractually, and they make sure of that going out of the bucket, right? When you are doing business with the card brands, it's, make sure you're PCI compliant, make sure you understand your reimbursement and your indemnification obligations with us, make sure you understand your processor's rights in the event you do have a breach, understand that we have the right to terminate. It really is one-sided. So there has been litigation. BJ's There was, I have it actually right here: fraud, negligent misrepresentation, breach of unfair, deceptive practices. TJ Maxx, obviously, breach and violation of consumer protection laws. I mean, we've seen it. Fewer and far between, and we've seen it. We've seen, again, issuing banks against the merchants. We've seen issuing banks against the merchant banks, but very much further and far between because they are taking care of it in the back end and contractually. Hence the reason why it's so much more important. The liability part is there. We're not worried about the liability not tapping and the policy doing what it's supposed to do from a liability standpoint.
So hopefully that gives everyone some clarity on the issue. I'm not sure if I'm any clearer, but we do want to open it up to questions. Hopefully this is an area that would generate some topics. So I see we have one in the back of the room.
Hi, Max Feder, Fox School of Business. It seems like the two landmarks in this industry have been in 2003, the California Online Privacy Act, and the TJ Maxx breach in 2007. I was just wondering what the expert panel thinks is going to be the next landmark in this industry.
I think from an emerging trend perspective, it's going to be an attack on a cloud provider with a substantial amount of accounts that are wrapped up within that cloud, which is going to potentially cause a catastrophe for the folks that are up on this panel.
And I happen to think that it'll be an attack that causes large property damage or bodily injury loss.
I think it's probably cyber crime related versus unauthorized access. So I think it's more theft of large amounts of money and primarily will impact the crime market more than it will impact the cyber market. Hopefully that's the scenario.
That's a whole other issue.
I think all the above, plus changing privacy regulations in the EU and the US, are going to completely impact what's going to systemic risk we might look at. And then also, you heard references to our relationships in Russia. We're watching what's happening with our relationships in China. All of these concepts of potential cyber warfare. I don't know that that's going to be a specific sea change immediately, but it's something that we're certainly all concerned about.
I'm going to go off of something Matt said. I think there's a significant change, and there's going to be a significant change in the crime market. So for anybody in the room that handles that line of coverage, you might know what I'm talking about in the fact that most insurers and large crime underwriters are issuing new endorsements to their policies on the commercial side. Not really as concerned on the financial institution side at this point in time, but on the commercial side of the house, if you have that theft of monies, which I don't think is going away. I don't know if it's the next big thing, but I think it's going to get worse. Our clients and our insureds have definitely been feeling that, whether it's through a phishing attack, the theft of an account number that it's all it is transferring of monies, and it's out the door and it's gone. You look at the commercial crime policies, and we've always wanted that loss to go there. Commercial crime underwriters are waking up. They're putting very large, broad exclusions on their commercial policies. That's a big concern for us.
And I also think that's a good example of the coordination between two different underwriting groups. So the crime group, cyber group, the expertise is on the crime side or cyber side, not the crime side when it comes to cyber theft. So I think that's a good example of kind of the synergy between the two. And then property, we'll see where that goes.
But actually, I'd like to go back for a second because I think on that timeline, the next milestone that we'll remember on that timeline, 3 or 4 years from now, will be the Target breach in 2013. So.
And you forgot Y2K too.
Yeah, and I look at what the courts are doing with all these cases that involve millions of breaches of personally identifiable information, even things as mundane as email addresses and passwords. And if the courts change course on that and start, saying that, the mere potential of you being breached, you could be awarded some actual damages, I think that would be, precedent setting and would change the market a bit. We have time maybe for another question or two or more. Anyone? Nobody said the pineapple mark. That was. They don't know what you know.
Any questions?
Going once, twice, one more.
All right, just for fun. So, New York Times is breached by the Red Army. Cyber terrorism, would you cover that? Can you go down and actually say yes, no, assuming there was, quantifiable damages?
That had to do with the second example that I gave was really state-sponsored type of espionage, and in that example, I'm sure that they're looking maybe at intellectual property, maybe they're looking at information, maybe they're trying to wreak havoc with the Times. I don't think it's been litigated from an intent perspective. I would say we anticipated covering that type of exposure.
Our client was hacked by the same group and the same week, and there was coverage under the insurance policy for that. Now, there's no liability, right? It's just a lot of expense, a lot of internal chaos for the time being, a lot of recreation and redevelopment of content in a lot of ways, which, no, that wouldn't be covered under the policy, but the costs involved to deal with a situation like that, at least in the case that we encountered, was covered.
Any what-if scenarios, I usually answer with I don't have enough information for that. But I also, would this be covered? I mean, the best response is the policy addresses this. So, you've got covered, uncovered, you've got, parts of it that would be covered. And with cyber, I think it's, there's a lot of elements that the policy addresses the response, and not so much is that covered. But the amount of questions that I get on a probably minute-by-minute basis with respects to what-ifs, it just shows you how much kind of potential there is for education and training and making sure that from both an underwriting standpoint, but also the broker community and the client community understand really the intent of these policies versus, are you going to give me $10 million for this? I mean, which is the way in which some of these questions are asked. So
What I would do is I'd put a cyber terrorism carve back on your war exclusion and make it affirmative so that you have coverage for it.
Yeah, that was really the focus of the question, was the cyber terrorism thing. And if it's the Red Army or, the Syrian guys, there's a lot of state-sponsored groups that are hacking commercial entities. So that, it's just it's about the cyber terrorism carve-out.
I think that's where Ken was going. I think you ought to make sure that the language is going to specifically address that type of a concern and make sure that the war hostilities exclusion isn't going to completely knock that out.
Okay. Thanks, everyone.